Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer, and if you're listening to us on one of the many fine podcast platforms at which you can find the Lunch Hour, you can always join us by watching us on YouTube. If you're watching us on YouTube and you want to take the Lunch Hour with you, where you can't just watch it, you can find us on just about every podcast platform that's out there. Leave us a like, leave us a subscription, smash down on the reviews, and let your friends know and your family members know and your family members' friends know that you are enjoying the Lunch Hour podcast. I'm incredibly excited to bring our guest on today. Her name is Karen Cook. She is a Dallas-based attorney with over 20 years of experience specializing in securities enforcement, regulation, and litigation, as well as white-collar defense and internal investigations. She is the founder of her own law firm, Karen Cook PLLC, which focuses on developing custom strategies to protect clients' interests, including both financial and reputational concerns. Before establishing her private practice, Cook served as an assistant director of enforcement at the U.S. Securities and Exchange Commission. This experience provided her with valuable insights into the regulatory landscape and enforcement processes in the securities industry. Her areas of practice include business law, criminal law, government and administrative law, commercial litigation, securities law, and civil and appellate work. As a former SEC official, and now a private practitioner, Cook brings a unique perspective to her cases. She leverages her insider knowledge of SEC operations and enforcement strategies to benefit her clients in securities-related matters. Her background makes her particularly well-suited to handle complex cases involving sensitive regulations and white-collar defense. She earned her JD from Southern Methodist University, and we're having her on because she is just fresh off an amazing victory in the United States Supreme Court. And let's just go right there, Karen. How does it feel when you have that moment as an attorney in private practice? I mean, this sets you at the pinnacle of your career. You get the Supreme Court decision on a case that you've argued, and the decision goes your way. What was going through your minds at that point?
It was a great combination of excitement and relief. We have, my partner, Mike McCulloch, and I have worked on this case for 11 years.
Wow.
And it's been a long road for our client, but we were very excited with the outcome and very relieved.
Yeah, I don't doubt it. And that's the thing. So by way of my own background, Karen, just so you understand, one of my very first jobs in the public policy world, and I wear two hats, I do both media and public policy, was I worked for a blind lawyer, constitutional lawyer, environmental lawyer. He and his wife had a nonprofit property rights focused law firm. And it was then that I sort of understood the idea that when you have a case that goes all the way to the Supreme Court, it can take almost a dozen years, if not more, to have it heard. There's a real perseverance that's at issue here. And, obviously, if you're a well-heeled client, you can afford that. But the vast majority of folks can't afford to take a case for a decade or more all the way to the United States Supreme Court. Tell us a little bit about that.
Well, part of the reason it took so long, to be honest with you, is because the agency itself sat on the case for 6 years. So just to give a little background of how it transpired, we were brought into the case after the SEC had initiated.
And hold on, let me interrupt. This is the Jarkessi case, if I'm pronouncing it correctly.
Jarkessi, yes.
Jarkessi, got it. The emphasis on the other syllable. Thank you very much. I'm sorry.
Exactly.
The Jarkessi case. Go ahead.
So George Jarkessi came to us in 2013 after the SEC had already initiated the administrative proceeding against him. So as we began to prepare for trial, we did a little analysis to go back to some administrative proceedings the last 2 or 3 years prior to see who won and how did they do it. And we discovered that nobody won.
Which is insane. And I want you to get into detail about that, because we've talked about this particular issue with both Ryan Young from the Competitive Enterprise Institute and Jessica Malugin at CEI about the issue of administrative courts. What is it with the SEC? 90% of their cases, the SEC has won. Talk about this.
Yeah. So years ago, decades ago, almost all their cases, regular cases, were just brought in federal court.
Yeah.
And it was when Dodd-Frank came along. I mean, over time, there was more and more creep toward, administrative proceedings. But when Dodd-Frank came along, it gave them the authority to bring any case against anyone as an administrative proceeding.
Wow.
So even if you are an ordinary citizen, you're not registered with them, you're not required to be registered. If they think they have a case against you, they can draw you into an administrative proceeding. And that's what happened to George Jarkissi.
Yeah, I mean, and let's talk about this actually, because I'm reminded of a quote, a case that changed my life, 1992 Supreme Court case called New York versus United States, in which Justice O'Connor, writing for the court, writes, "The Constitution protects us from our own best intentions. It divides power among sovereigns and among branches of government precisely so that we might resist the temptation to concentrate power in one location as the expedient solution to the crisis of the day." In other words, the Constitution creates, and it's supposed to create a deliberative government where we deliberate over public policy so we can look at the unintended consequences. So you have the Dodd-Frank financial services regulation, or the statute, and then the regulations that go there. They create this opportunity for the SEC, and then all of a sudden, all of these cases are being brought in the SEC's administrative courts. And of course, you've got massive home field advantage, 90% of the cases going their way. Talk about that a little bit.
And in addition, they have their own employees who are deciding the case. And so
Right.
the home field advantage is unbelievable, and it proved to be impossible to overcome. And so once we realized they had a virtually 100% win rate, and we felt that wasn't an acceptable outcome for our clients, right. So we began to look at the Constitution and the enabling statutes. And that's where we started to develop the arguments that we eventually claimed and brought to the Supreme Court.
And let's talk about this because, one of the justifications that is given, or at least have been given for many, many years with these administrative courts, is that they couldn't levy criminal penalties, right? I mean, it was a different proceeding with different standards of evidence, and therefore different kinds of outcomes could be had. But at some point in time, this changed. What changed, and how did it impact the fairness, the justness of these administrative courts?
Well, the home field advantage, when you have your own employees that are deciding the case, all of a sudden everything changes. And I do want to really point out that you don't have the federal rules of civil procedure, and the rules matter. And if I have a moment, I want to give an analogy that I think that will help people to really understand. They say, well, these administrative proceedings, they're flexible, they can be quicker. Okay, well, all of that proved to not be true in our case.
Right.
If you can imagine a basketball game, and you go to a basketball game and the home team is the government and the visitors are the defendant. And you show up and the game begins, and all of a sudden the referees are not calling any fouls on the government.
Right.
The home team, they can commit any violation, they can take any tactic they want, and there are no fouls called on them. And yet very stringent fouls called on the visiting team.
Right.
When you get to the end of the game, all the fouls and the, sending the government back to the free throw line over and over and over. When you get to the end of the game, if there are more points on the board for the government, the home team, did they really win?
Right.
And that's the point with why the rules matter. And you don't have rules that are applied evenly or even fairly, you can have very unreliable evidence coming in by the government, and then the ALJ will hold it out, similar evidence as to the defendant. And it's just not fair.
I don't know if you remember the movie from the 1970s, Billy Jack. But at one point in time, Billy Jack says, when those in power can ignore the law, then there is no law. And that's, let's talk about this. Let's sort of take a step back here and talk a little bit about your journey, Karen, because as we talked about in your bio, you were an SEC enforcement lawyer, but I'm sure you were practicing in federal court. Let's talk about, why. Right now, I'm someone who deals with a regulatory state, and I often talk about ridiculous regulations, and we talk about the importance of due process, and all those things are absolutely important. We're going to get back to this. But let's also talk about why the laws exist. The underlying statutes that give the SEC, the Securities and Exchange Commission, its underlying power. You're not arguing with that. At least I don't think you are. I'm not arguing with that. But talk about why those powers exist. Why do we have a Securities and Exchange Commission, and why are the regulations that they enforce important?
I would argue that the full disclosure laws, or the full disclosure, which is a concept that really underlies the federal securities laws, that if you give people full disclosure, they can make good decisions on investments.
Yes.
Those full disclosure rules and our accounting and auditing rules, I think, give us the best and most fair markets in the world. So the work of the SEC is very important. It helps to keep things fair. Unfortunately, given more and more enforcement power, they were diverting so many of their cases to the home field advantage. And what happened is they were able to leverage settlements because people knew you can't win. Yes. So what are you going to do? You're going to agree to a settlement to try to get something better than, walking into the moving propeller. Yes. And so now that they have to go back to federal court to bring their cases, which is where they were in the beginning, they have to weed out the marginal cases or they're not going to win. Right. The rules of is this mistake someone made, is it material? Is it important enough to be a violation of the law? That's going to be enforced differently in federal court.
That raises an interesting question, because I've had this conversation. I actually had my former boss on because he was the Assistant Attorney General of the Lands Division of the Justice Department. And we talked about the erosion of the concept of intent. And as someone who practices the law, let's talk about this, the erosion of intent, the moving away from specific intent to more general intent. How does that impact you when you're going up against a federal agency, in federal court or in an administrative court? Tell us about that.
I think this is another aspect of the home field advantage. If you took the same case to federal court and the judge looked at, okay, the government is alleging you made certain mistakes, or certain statements were made, or certain transactions occurred, and that these are violations of the federal securities laws, there is a mental state that is an element that has to be proved. Yes. When you go to federal court, it seems to me that mental state is meaningful, and it is enforced in a more uniform way. In my experience, what happened at the SEC in their administrative proceedings is it became very close to strict liability, meaning if you made a mistake, you are liable. It doesn't really matter your intent or how big the mistake was.
What does that do generally to society? I mean, that to me, it puts, so, you have Henry Silverglade, who wrote a book called 3 Felonies a Day. And the thesis is that the federal law is so vast now, or the state of law generally is so vast now, that the average American commits 3 felonies a day. And obviously, depends on who you are. But when you remove the concept of specific intent and you move it out to general intent, that puts us all in great jeopardy of having, our all kinds of abuse of power. Your thoughts here?
Yes, and I would say that in my experience, there are some people, and we can think of like Bernie Madoff and people like that, who seem to have had a genuine intent to cheat people, right? Yeah. They had, you look at the bank records and you look at the emails and so forth, and you can see lies and you can see misappropriation of money. Okay, those are clearer cases. But it's my experience that most people operating in the securities business really are trying to do the right thing and are trying to do a good job and just make a good living. And sometimes they make a mistake, or they're not doing things in exactly the way that other firms might do them, and they could be doing them better. And so to me, one of the roles of the SEC's regulatory division is to speak to these firms when they examine them and help them to do it correctly. Because most of them, if given the chance, if they're doing something wrong, they will correct it and do it right. Right. And so there should be less of this game of gotcha going forward, and more of, I hope to see more of assisting firms in doing things correctly and only bringing meritorious cases before the courts.
You know, it's interesting. Back during the George W. Bush administration at OSHA, there was a program that they developed called OSHCON, which was an OSHA consultative program. And the idea was that if you were a business, especially a small business, and we all know how, I mean, we're going to talk about this, the issue of the complexity of SEC regulations. It's the same thing with occupational safety and health, right? And so you would have an OSHA inspector show up at your business and they would do an inspection. And I know folks get chills because they would think, well, I'm from the government and I'm here to help, but stay with me for a second there. And the idea was that they would write up your list of violations, but they weren't going to engage in an enforcement action. What they would do is they would give you X number of days to correct the infractions. Then the OSHA inspector would come back, inspect again, and if everything was according to Hoyle, they would give you a certification that you could then take to your workman's comp insurance provider, and you would get a break on your workman's comp insurance. And it was a really great cooperative way of getting to what we all want, which is if there are rules out there, we want folks following the rules, right? That's the level playing field. And it's what we as a society, at least nominally, have decided this is what's important. But of course, the criticism of the George W. Bush administration was that their OSHA was not bringing enough enforcement actions, because you had some bean counters out there said, well, the number of enforcement actions has gone down. And of course, the next administration comes in and they get rid of the OSHA consultation program. I want your thoughts on this and this cooperative approach. And my thesis that if we have these laws out there, we want people able to understand and enforce the law, don't we?
We do. And I would say that this regulating by enforcement is so damaging to business, and it's wrecking people's lives. You know, it's very expensive to defend yourself against the government.
Right.
And in addition, the stress, and in our client's case, there were other partners that he did business with, and let's just say generally, without being too specific, you know, banks or insurance companies or just other, you know, companies that people routinely do business with that, you know, were troubled by the case being out there. And
Sure.
So your borrowing costs are higher. You have trouble getting the business partners you want to do business with. So the cost is way more than just your attorney's fees.
Let's talk about your client, George Jarkissi, as I'm now pronouncing it hopefully correctly. You know, he comes to you with this and he understands the deck is stacked against him. But then, as you said, the case laid fallow for how many years?
6. So,
so yeah, I'm sorry, go ahead.
Well, the first thing we did when we realized we were just, you know, walking into a certain loss, when you know that they win 100% of the time, anybody with common sense can conclude that probably the situation is not fair. And so we began looking at the Constitution and the statutes, and we first brought a lawsuit to stop the administrative proceeding, and we filed it in the DC District Court, and we were ruled against on jurisdictional grounds.
Okay.
So we were told we had to go back and finish the entire case before we could bring up our constitutional issues.
Hold on for a second. In the property rights arena, they call that the Tucker Act shuffle. You haven't exhausted your administrative remedies, so therefore you got to go back to the administrative court. Go ahead.
And I want to add to this. We did appeal that to the DC Circuit, and it was affirmed. The dismissal was affirmed. However, since then, a case called SEC versus Cochran reversed that at the Supreme Court. So now, if you have structural constitutional challenges to an action, you can bring that up front instead of going through the entire years-long proceeding. Yep.
Wow.
So we then went back and went through the trial, and
hold on. The trial, we say with air quotes. Go ahead.
I thought I would be polite and not use the air quotes, but yes.
I will use that for you, yes.
So after the SEC had taken 2 years to investigate Mr. Jarkissi and his businesses, we had then just a few months to prepare our defense to it. So that as well seemed unfair to us. We
Sure.
did go through the hearing. it was as bad as you'd expect it to be. And then after completion of that, we had to wait several months for the administrative law judge to issue her opinion. Of course, when the opinion arrived, all of the findings were against Mr. Jarkissi, with all of the remedies requested by the enforcement staff were granted.
And talk about the relationship. They're supposed to be independent, but talk about the relationship between the administrative law judges and the enforcement staff. I mean, they see each other all the time. Obviously, as we've said, 90% success rate or higher than 90% success rate, but they're not really independent, are they?
They're not. And I don't know if every agency is the same, but at the SEC, we had a pre-hearing conference where we had raised some constitutional and due process issues. And during the hearing, the administrative law judge was summarizing our arguments and said something like, the defendant doesn't think we've done enough. And I thought, well, I don't know who we means, but it's got to mean the ALJ and the Division of Enforcement.
Right.
And so we knew we were in trouble then.
Right. I mean, again, that would certainly in a regular court of law, that kind of a prejudicial, favoritism statement would be grounds for an appeal. And talk about that appellate process. So when you get the ALJ, the administrative law judge decision, where do you go from there?
Then the next appeal is to the commission itself. That's the first line of appeal. And so we did that. We filed an extensive appeal that included many due process issues related to the proceeding itself. And then in addition, several constitutional issues. And I believe we raised 5 constitutional issues in addition to the due process issues related to the case. We brought them to the commission, and then the commission sat on that appeal for 6 years.
Wow. I mean, and there's nothing you could do to move them along, obviously. I mean, what years, what was this happening? So I get a sense, was there a change in administrations? When was that?
Well, there was. And so in 2014, I believe, is when we have filed the appeal with the commission. And then I believe it was 2020 or maybe 2021 when the opinion of the commission was allowed to go final. They issued their final opinion. That was the first time we had the right to appeal to an Article III court.
Wow.
And so we then promptly filed our appeal with the Fifth Circuit Court of Appeals, which we were entitled to do because George Jarkissi lives in Texas.
Yeah.
And it was at the Fifth Circuit. We brought 5 issues to the court, which I know some people would think of as crazy, but in our minds, there were so many things wrong with the authority for the proceeding that they're all kind of related to each other. And so we brought all these issues. The Fifth Circuit issued an opinion that found for us on 3 issues and ignored the other 2.
Okay.
And so
3 out of 5 is still 60%. That's not bad.
Well, right. And it was still unusual. To win on 3 different issues was really unusual. And we were grateful to the Fifth Circuit and to the analysis and the attention they paid to all of those issues. And so the SEC itself then had to file the petition for cert to the Supreme Court because they went up as the losers.
Yeah, right. And they didn't just want to end up with the losers. Now, at the same time, was there continued harassment of Mr. Jarkissi? Because I know, I'll give you a really good example. While Suzette Kelo was dealing with her case against the Supreme Court in the early 2000s, the city of New London, Connecticut was relentless in harassing her at every stage of her situation. They didn't, or did they leave it alone as this was going on?
Well, I think that the delay was meant to be a punishment, to be honest with you.
Right.
And what's interesting is by the time his case was allowed to go to the Fifth Circuit and then to the Supreme Court, There had been a number of appointments, both to the Fifth Circuit and the Supreme Court, and I think that changed the complexion of the court and
Sure.
led to the outcome that we have.
Well, okay, so now let's fast forward, because now I'm going to make a very generalized statement and say that every young JD or every law student, taking their first year constitutional law class dreams, or many of them dream of that day where they will be standing in front of the high court, the 9 justices on the high court, to argue a case. And I don't know if this was your dream, but what was that like, stepping into the Supreme Court for that argument?
It was amazing. I would say if you go to a function and you have one Supreme Court justice who's there to give a speech, and you always feel really honored to be able to be in their presence and hear their perspective and hear what they have to say, and to literally be in front of all 9 of them was really an amazing experience.
Well, and all 9 of them where they're intently listening to what you have to say, because they've decided that this case and the issues in this case are important enough and have long-ranging and long-lasting impact that they need to hear it and decide on it. The arguments themselves, I mean, obviously, I want you to talk about what went on between you and your partner and Justice Kagan, but also the other justices and how they sort of received your arguments. So tell us about that.
So my partner, Mike McCulloch, he and I decided, we had 3 issues. The court granted cert on all 3 issues, and in the end, they only decided 1.
Yeah.
So we had to prepare for all 3 issues, which was really a big undertaking.
Sure.
We briefly considered breaking up the argument and having me take 1 issue and he would take 2 issues, and that might give him a chance to sit down and regroup his thoughts. And then in the end, and I'm so glad we decided this, we just decided the issues were so intertwined that it might kind of stunt the intercourse with the justices, and just allow just really a free flow of discussion. And that was really the right decision. And so Mike did the entire argument. It was a really long argument. I think at the time it was the longest one that had occurred in the term, and it may still have been the longest one. They did focus on the 7th Amendment the entire time, the right to a jury trial. We did get what we thought were some positive questions that we thought were positive from the chief and the other conservative appointed justices. And then my partner did have a really interesting interchange with Justice Kagan, who is an expert on the administrative law. Okay. And so we were expecting that she would have some really challenging questions.
And so what were they? What did she ask about?
Well, one of the cases, there's a case that had been in place for a long time that I guess I would say it served as the basis for the notion that Congress could assign cases to administrative proceedings and then take them out of the Article III courts. And, so there was some discussion about that. And I think that for the people who've listened to the oral argument, the interchange between them that people found most interesting is that I think Justice Kagan was trying to make the point that, hey, this has been settled law for 50 or 60 years. And, it takes chutzpah for you to have brought these arguments to the court. And knowing my partner like I do, I knew immediately he would just accept that as a compliment. Sure. I don't think it was meant that way, but but that is how he took it, because I think it does take chutzpah sometimes to challenge something that's been settled for a while, or to challenge something that most people do accept as the way it is or the way it's going to be.
Well, like the aforementioned Suzette Kelo case, right? Which this issue of eminent domain and what constitutes public use under the Fifth Amendment of the Constitution. Yeah, now that law has changed over time, but as you point out, the complexion of the court has changed, right? The outlook of the justices on the court have changed, and these are important enough issues that you go down. You have to raise them from time to time. Remind me, I confess, and I apologize for this. Who wound up writing the opinion for the court? What was the makeup of the breakdown of the deciders?
It was the chief who wrote the opinion.
That's right.
There was a majority opinion, and then there was a concurrence that was written by Justice Gorsuch, and then the dissent, I believe, was written by Justice Sotomayor, and it was joined by Justice Kagan and Justice Jackson.
So in thinking about this, I mean, you talk about the changing makeup of the court, and it used to be that you could invariably count on the more progressive justices to understand and make arguments in favor of recognizing the importance of substantive and procedural due process issues, but also, the role of the difference between, what a federal court does in terms of to recognize that almost our entire justice system is based on ensuring that the rights of those accused of criminal acts are protected to the fullest extent possible. Somewhere, I think we've lost this, which is very, very strange to me. Tell us a little bit about the breakdown between the main decision, Justice Gorsuch's concurrence, and then the dissent. How did the things fall out that way?
They're very consistent, but I think that the majority opinion, the chief made it very clear that the right to a jury trial, applies here, and even went so far as to say, also, you're entitled to be in an Article III court.
Yeah.
I think that the concurrence is meant to make that even more clear, so that, this is just my opinion, but just so that the agencies don't say, well, if we need to give a jury, we'll just go get 6 people down the hall, we'll call them a jury, and then we'll just keep doing what we were doing, right?
Wow, yes.
So I think that the concurrence was meant, as well as, to supplement the majority opinion, and to say, not only are you entitled to a jury, you are entitled to be in Article III court, and you're entitled to due process. You are entitled to all 3 of those things. They are constitutional protections. And that helps to restore the balance of power and the separation of power that was meant to exist between the agencies and the courts.
And the dissent then, I mean, did they disagree with everything? I mean, it seems to me that these are, as you say, bedrock principles of American jurisprudence. They nothing to say about the history of potential abuse of power amongst administrative courts, essentially becoming quasi-modern star chambers. What did Justice Sotomayor have to say?
They look at the more recent history with this case called Atlas Roofing, and that was the one that had, existed for 50, 60 years. And it seemed like the one that they were standing on to protect this authority of the agencies to have these administrative proceedings. And we took on Atlas Roofing and just took it on its word, and really came to the conclusion that it didn't apply in our case. So that the court really didn't even need to overrule it. It just didn't apply. And but the dissent, I think, kind of viewed it as a power grab, but I would say that it really just restored the power and the separation of powers that existed before Atlas Roofing, and it brought it back into its right relationship.
I mean, it seems to me, this is why these cases are so important, right? That the administrative state is so vast. Yes. And the amount of regulations that folks are responsible for knowing, and now, as we were talking about with the erosion of the concept of the intent standard, that these powers, these administrative powers, can be abused. So much of what the good work that the court is doing is reining in those kinds of powers. So whether or not it's this case, the Jarkissi case, Yeah, right. Jarkissi,
Yes.
or the Loper Bright case, or any one of a number of other cases in which sort of that restoring this balance of power. Let's go there before we finish up. Talk about the importance of this balance of power in terms of the protection of individual rights.
Well, it's key to protection of individual rights, and it's very fundamental if you go back to this concept. If you concentrate power in the government, that necessarily takes away powers from the individuals.
Hear, hear.
And so the separation of powers between these three branches of government is very important to protecting individual liberty.
Yeah.
And so I believe that the court between Jarkissi and Loper Bright has helped to restore the separation of powers that is supposed to exist under our Constitution, that helps to protect individual liberties. So now, when you are brought into a lawsuit with the federal government, which has extensive power and resources, so it's already a formidable opponent. When you are brought into that, if you are in federal court, you have an independent fact finder, you have procedural rules, due process, you have so many constitutional protections that will make it more likely for the right outcome.
There you go. The federalism secures to individuals the liberties that derive from the diffusion of sovereign power. Also from New York versus United States. So listen, Karen, because I know your time is very valuable. But I do ask all of my guests this. Well, actually, two questions. So number one, you've got your taste of arguing successfully before the high court. Are you relishing the opportunity to do it again?
Absolutely.
Yeah.
As we walked down the steps that day, we looked at each other and said, let's go do that again.
There you go. It's like riding a roller coaster. So when you're not doing this work, and I at one point was conceiving of doing a podcast called Outside Interests, in which I talk to government officials and policymakers and other folks, think tanky folks, about what they do that's not the policy work that they're doing. When you're not engaging in your law practice, when you're not arguing cases before the high court, what are you up to? How do you spend your spare time, if you have any?
Well, I have a big family, so I mostly spend my time with my family, but I enjoy outdoor recreation. I enjoy reading, and I enjoy music. So, and I enjoy my family.
There you go. Well, listen, thank you so very much for joining us today, Karen Cook.
Thank you for having me.
This has been yet another episode of the Lunch Hour with Federal Newswire. As I've said, our guest was Karen Cook. She is a lawyer from Dallas, Texas. As I've said, you can listen to us on every fine podcast platform imaginable, pretty much. If you're listening to us on one of those fine podcast platforms, you can watch us on YouTube. Please subscribe, leave a review, leave a comment, and let everybody in your orbit know about the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer. Enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream.